Hello, I'm Dominic Walker, JMW's Inside Man. My guest is Tom Baylis. Tom is a solicitor in JMW's commercial litigation department, and Tom specialises in property litigation. So, Tom, I believe there's this new code of practice that's about to be introduced by the government for commercial landlords and tenants. I just wonder if you could tell me a little bit about it, please.
That's right, Dom. So the government's now revealed its proposal. It's announced its proposal for dealing and tackling with rent arrears that have accrued during the COVID-19 pandemic. In very short terms, it's introduced a new binding arbitration process and a code of practice which offers guidance to landlords and tenants on how to negotiate repayment of rental arrears, essentially. The aim of the proposal and the code is to hopefully keep businesses trading, hopefully allowing tenants to trade through the difficulties and find a settlement with their landlord, rather than having to jump straight to the issuing of court proceedings. And the code will outline a new process, as I say, for settling those arrears up until the 25th of March 2022. It's really aimed at trying to encourage tenants to approach the landlords to discuss the difficulties they're facing, the hardships they're facing, and for landlords to really seriously consider reasonable proposals that their tenants are putting to them. From March 2022, there'll be a new legally binding arbitration process that will be implemented for those that have yet to reach a settlement following the new negotiation regime. And that arbitration will result in a legally binding agreement which both the landlord and the tenant needs to adhere to. So it's essentially creating a new step, hopefully, that landlords and tenants can engage in before having to jump straight to enforcement, and hopefully allowing more matters to settle on a more amicable basis, really.
And is everybody covered by this, Tom?
No. So the new regime, the new proposal will only cover commercial rents, so commercial tenancies, and even then there's a further subset. So it will only cover very certain scenarios. So it covers those commercial tenants or businesses that were forced into a mandatory closure, whether in full or in part, for the period 21 March 2020 to the 18th of July 2021. So we're really looking at the service industries, gyms, bars, restaurants, and as I say, it will only cover the rent that has accrued during that period. It's not yet clear from the wording of the code whether those tenants that have implemented a voluntary closure will be covered. And even if you do, if you do qualify for the new proposal, Dom, tenants need to be mindful that there is a deadline in place as well. So while either party can unilaterally apply, there is a deadline by which to apply, which is 6 months from the date on which the legislation is implemented, and a maximum time to repay of 24 months.
And it sounds to me like it's probably good news for a tenant, not so good news for a landlord. How can you and the team at JMW help, Tom?
Yeah, that's dead right. So it's essentially created a breathing space for the tenants, allowing them to hopefully trade through the difficulties. And you're right, it's going to not be great news for landlords, really. It's severely clipped their wings in terms of what they can and can't do about rental arrears, provided that their tenant qualifies for the process. So, for example, they'd be prevented from issuing claims for that period. They'd be prevented from utilising the commercial rent arrears recovery process, and the moratorium on forfeiture for rental arrears is still in place until the 25th of March 2022. There is, however, still things that we can do at JMW to assist. So we can guide tenants through the process. We can hopefully ensure that landlords are complying with it before they do something that maybe it would be the issuing of proceedings where their tenant qualifies for the new proposal. And let's not forget, if the rent was accrued before the mandatory closure, the deadlines are set out earlier, then we're still able to issue claims for landlords to recover the rent through court proceedings. And if we've got landlords, for example, that are facing difficulties with tenants, maybe there are other breaches of covenant within the lease that don't necessarily relate to rental arrears, then we can still look to forfeit those leases. So there's still options available. But yes, you're right in that the overarching theme here is great news for tenant, not so great news for a landlord.
Tom, thank you very much for your insight. And if you'd like to speak to Tom and the team, you can email insideman@jmw.co.uk or call 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.